Hey, right, everyone, just bear with me a sec. Yeah, cool. Okay. Yeah, welcome everyone to this week's live stream. As always, it's not legal advice, so we're going to do our best here to be useful. And if you could completely refrain from sharing personal data on the chat, that'd be awesome. So if you've got a question, make it as if it's about a hypothetical person, basically. So make it a what if question. You'll get a better answer anyway, and it means you don't have to stick all your personal data onto the internet to get an answer. Um, hey, right, guys. Well done for being on time. That's unusual. It's good. Few bits and pieces. I haven't actually checked with the other guys if they've got any gossip, but I've got a couple of bits just want to talk about. One is that me and Will are doing a couple of free webinars in the next few weeks or so. So the next one is one which is kind of aimed at SWEP workers. So SWEP is the Severe Weather Emergency Protocol provision, which kind of opens up in severe weather in England, and it's generally staffed by a mixture of kind of paid staff and volunteers. So often, kind of people who that this might be their first kind of contact with the sector. And so, although we're going to cover the basics of the law, I think we're also going to talk a bit more broadly about kind of other housing options and how they all fit in with the law. So I'm just digging out the link for it here. So it's free. It's 3:30 next Tuesday, 3:30 till 5 p.m. And then a couple of weeks after, on the 11th of November, we're doing another one, which is basically focusing on the bits of housing and homelessness law which are relevant to domestic abuse workers, which is getting much better response so far. We've had like 60 responses, only open a few days. Again, it's free, so have a look at that. But yeah, I'm just thinking for the one next Tuesday, for those who come to the live stream and kind of regulars and kind of ask kind of questions around this sort of stuff, it might be something you guys might want to come along to as well, because it just yeah, as I say, it's kind of go back to basics a little bit and just kind of set the fundamentals of how all this stuff works together. So that's I think the gossip from me. Plus the usual kind of training courses going out there. So I'm delivering the priority need training tomorrow. The next one of them is on the 21st of November. And the next, if you want to come to the introduction course, it's a week. The next one's a week tomorrow. So you need to book on today or tomorrow. Basically, the bookings will shut. So yeah, any news from you guys at all? I saw we've got to say big up to Will, because Will was in a case recently, Court of Appeal, I'm assuming, and it's, well, if I'm reading it right, Will, all the judges made a comment to say that you were, the client was very lucky to have you as a solicitor, which was nice to read. I think it was just like it was I think more than one judge said it. If,
But it's in the judgment at the end, which is really nice. And they were echoing the county court judge had said something nice about me, and they echoed that. And then the barristers were doing that as well. But it isn't in the judgment. But if you had the transcript of the hearing,
well,
but
the other guy's barrister, the council's barrister as well.
yeah, yeah,
All right, okay,
yeah.
cool.
But it's sort of it's not unusual for them to do that, because if they're trying to sort of get the judge to give the client a hard time, they'll say, and he had an excellent lawyer, so he's got no excuse.
Okay,
Um,
but the judges
so
said it this time.
yeah, yeah. And the thing is, it's such a small world now that we all know each other, all these people. Um, so I know the barrister for the other side quite well too. So it was nice to see him again, even if he did win the case.
And when do you find out if it's going to the Supreme Court?
Well, we will within the next couple of weeks, we'll apply for permission. Well, subject to legal aid, we'll apply for permission to go to Supreme Court. And there's another case which is going to the Supreme Court on a very similar point. So they may give us permission to go there as well, or they may say no, you don't need to, but we'll see. Um, but
Yeah,
I've just got so many cases on at the moment. I haven't had time to. I haven't even read the judgment, which is
yeah,
bad. Apart from the nice bit about me at the end.
yeah. That's good. Cool. Hey, you what, guys? Are you all right, Martin? So there's questions already in the live stream there. We'll circle back to them. There's one or two questions that have come in through the week that are anonymized. We'll start with them. Karis and Shannon, you got anything you want to share at this point? No? Cool. Okay, cool. Let's get into it then. So actually, I mentioned these as well. There's been a couple of I've been going back over the local government social care ombudsman decisions that they publish. if you haven't signed up to the LGO website, you need to just search for lgo.org.uk. Down the bottom somewhere, there's like a newsletter thing you can sign up to. Every Thursday lunchtime, you get a bunch of decisions, and there's some really interesting ones this week. So, for example, and I haven't had time to read this one properly yet, but I can tell it is a good one, because it's about out of area placements and kind of kids' education and a lot of kind of questions that come up on the live stream a lot where people have been placed out of area. So the summary here is the council was at fault for delay providing Miss X and her children temporary accommodation, failing to consider its main housing duty and giving Miss X insufficient time to consider an offer. That's a kind of another frequent thing that comes up a lot. This meant delaying Miss X moving back to the area where her support network was, and it disrupted her children's education. And I don't know how much she got for it. So looking at that, 1,100 quid. I think I'm not going to break it all down there, but yeah. But within this decision, there'll be a lot of stuff, a lot of the kind of questions that come up on the live stream, they will be answered by the LGO here. So I'll probably end up going to do a video about this as a standalone because it's a good one. And then um, I'll get to this one in a minute. There's another one today about it was Basildon, and basically the complaint wasn't. I really felt for the advocate because I think there's an advocate involved. The advocate basically complained that this applicant had been left in unsuitable B&B accommodation for more than 6 weeks. I think I assume that's what it was. I didn't read the full detail. And what Basildon apparently do is they'll put a microwave in the hotel room and say it's self-contained. And the LGO basically said that's out of our remit. We can't make a judgment on whether it's suitable or not. You have to go to court. So I feel for that advocate, whoever it is out there, that did that hard work and got that response. But it's I guess it's helpful. It's instructive in a sense that if you have that issue come up, you need to push it into court and get it, get a solicitor involved rather than try and do it through the LGO because, as I say, they basically said we can't make a finding about it. It's for the courts to decide whether accommodation is suitable or not. So yeah, but if we'll talk about this Barking and Dagenham one here first. So the question, I'll read the question out. We'll go back to it. You'll see it on the screen in a minute. But basically, the question is, what if you're disabled and living in a council home and I think that basically there's neighbourhood issues. They're actively causing you harm from noise pollution perpetrated by neighbours for years. This affecting your emotional and psychological well-being. What then? The council have not resolved the noise issue and has let it carry on for years after making multiple complaints, refused medical housing application on the basis that noise is not a medical issue, had legal advice that I now have to make homeless application. I'm scared I will lose my flat. Any advice would be most helpful. So this is not something I've personally had a lot of experience with, but this Barking and Dagenham LGSCO decision here is fantastic because essentially the complaint was there's a guy, I think he had autism, and that kind of caused him to be hypersensitive to noise. And to be fair to the council, they did a lot, but they still got a lot wrong. So basically, they kind of I think they sound insulated the property, but not kind of adequately. They did a bunch of other stuff as well. But again, what we see with this LGO decision is the kind of they walk you through what the law is, and there's some interesting stuff in here which is relevant to the question here. So, for example, I think these paragraphs here are quite useful. So, paragraph 23, there is no fixed point at which something becomes a statutory nuisance. Councils rely on suitably qualified officers to gather evidence. Officers may, for example, ask the complainants to complete diary sheets, fit noise monitoring equipment, or make site visits. Councils will sometimes offer an out-of-hours service for people to contact if a nuisance occurs outside normal working time. And then 24, the law says that a potential nuisance must be judged on how it affects the average person. Councils cannot take action to stop something which is only a nuisance to the complainant because they have special circumstances, such as a medical condition which makes them unusually sensitive to noise or fumes. So that's helpful that they kind of set it out so clearly there. So what happened in this complaint is this guy does have a disability. It was he wasn't being annoying or anything. He just generally did have this issue, and it's one of the longest LGO decisions I've seen for a while. I think it's over 100 paragraphs, and there's a lot of detail in there. But it kind of talks about kind of how they consider soundproofing. There's a lot of good stuff in here to learn. I'm going to digest it at some point. But they did things like there were, as I say, there were plenty of failures in there. And yeah, they ended up kind of saying they were going to get him a bungalow, but they didn't. So this is kind of all the fun. You can let me put the link in the chat in a moment. And also, just to say this as well, this is a joint, I think this is a joint investigation between the local government and social care ombudsman and the housing ombudsman service, which again is something they've started to do more, I think, recently, but it's good to see because they kind of have separate remits, but here we see one that's overlapping. So yeah, he gets few £100 compensation, but I think essentially there was kind of a commitment again to actually, oh yeah, no, there's actually more compensation here as well. So there's a payment from the housing ombudsman and the LGSCO, and I think essentially there's something in there about kind of prioritizing for another property. So let me just put that link into the live stream for you to have a look at. You can also get it on the database that we've got. We'll talk about that later probably. But yeah, so let's go back to the question and just see if we've actually answered it. So yeah, there's the question. So let's just kind of, yeah, we're not going to answer it fully here because, as I say, it'd be a case of reading through that LGSO decision. But I think one thing to say here is that I would say that in this situation, from what I understand, the best thing you're going to hope for that's going to actually end the noise is going to be moved. The council, I don't think are going to be able to stop, well, there's a potential that the council won't be able to um, actually kind of, take other action depending on what the circumstances. We don't know here whether this person has a disability as such, or when in fact they say they've got a disability, but it doesn't say what the disability is. But I think making a homeless application is not going to do you any harm in the sense that it's a shot to nothing. You're not going to lose anything by doing it because you can always turn down offers of accommodation should they be made. And also by doing so, you're going to motivate the council to actually, for the housing team to march over to the ASB team or the environmental health team or whatever to make sure they're actually doing everything they can do. So as I say, I don't think it's a bad idea to make a homes application, but I think there's a chance here that actually the council may well not have adequate powers to fix it, and therefore, the best thing they can do is move you. So yeah, that's my answer. Do you guys want to add anything at all to that?
No.
No? Okay, cool. So we'll get into the live stream questions now, and there was a couple more questions we can come back to in a bit. So just see what's going on here. Bear with me a sec. Okay, I don't know if have I missed a bit of this question. Let's see what we've got here. Okay, so unless I missed a bit, it says she wants to approach the council as she fears she's going to become homeless and is now unemployed and on UC and cannot afford private rent as well as being in her current mental state. Have I totally missed a bit of this?
You've not missed the beginning bit, but you've missed follow up.
Okay. So well, let's just put this together then. Just to say, as I always do, guys, there's no character limit if you ask a question on the comments on the videos during the week. So yeah, it just kind of saves you, sort of having to piece it all together. How saves me having to piece it all together. So yeah, I think that's it. So does she have a case, or will the fact that she's coming from private rent hinder her application in any way? So I can't see what the actual situation is. I can't, unless I'm in stupid there, I can't see what the actual full question is. So until that makes sense to me, I can't answer it basically. So yeah, I don't know. No, none of us can see more to it. I think there might be. I think this person might have just kind of like missed off the first part of that question. So we'll leave it up there and go to the next question and come back to that one. So hold on a sec. So someone just asked me that case from Will. So let me just get that into the chat as well.
I've put a link to it in the chat.
Yeah, got it. Let me stick it into the live stream. Cool. Yes. If you want to have a look at that, I mean, it was actually broadcast, so I was watching a bit of it, and it was very tedious. So I felt for everyone there who were just kind of. I mean, I don't know how long it lasted, but it was a lot of kind
All
of.
day, a very long day.
Yeah, it looked like a long day. So okay, done that one. Okay, right. Next question I can see here. is this one here. So what can a family do if the 56 days of the relief period is passed and the council not responding to emails about the main housing duty? This concerns family with children after a court possession order. So I'm going to assume here that this family is not intentionally homeless, and therefore they are going to be owed the main housing duty, and therefore the failure to issue a decision on day 57. So basically the guidance says that in most cases the council should reach that final decision on day 57 of the relief duty starting, so the day after, after 56 days. And in some cases of particular complexity, they can take up to another 3 weeks. So that's probably not going to be the reason that they're delaying. It's probably they're understaffed and everything. You want to get this sorted out as soon as possible, because delays are just going to be delaying how long it takes you to get housed. So, and in this situation, if it is clear cut that you're in priority need, you're not intentionally homeless, then I'd say there's less danger of complaining at this stage. I say that because you can sometimes get retaliatory actions from the council if you complain. But in a case which is clear cut like this one, or looks like it's clear cut, I would simply complain. If it was me, I would complain to the chief exec and say, I made an application on this date, the relief duty started on that date, the relief duty ended on this date, and I've still not had a final decision on my application. And that's basically delaying me getting rebanded and kind of all the other stuff that goes with it. And send that to the chief exec and copying the local councillors that are relevant as well. That's just what I would do. That some people might see that as going overboard, but I just think it's important to understand that they have a legal duty to do stuff. It's there because it matters. If you just allow the council to get away with it, then well, that's your choice really. But it's not gonna, it's not gonna kind of fix itself probably. So I'd basically, kind of pursue it now. Yeah. Anything to add to that, guys?
I should just say I have created a template judicial review pre-action protocol letter for the situation where the 56 days goes by and nothing happens. Um, I've sent it a couple of times, but I've never had to act on it and actually issue judicial review proceedings. But I just got it up on the screen at my end here, and I can see that so I'm sorry if you mentioned this while I was looking and I missed it, but the code of guidance is quite strictly worded about this at paragraph 1417. It says that the local authority should be looking to notify the applicant of whether a full duty is accepted on or around day 57. And the idea there is that I think what goes wrong with a lot of authorities and what the code of guidance is trying to avoid here, or is not assuming happens, is that at the beginning of the relief duty, they say, okay, accept a relief duty, send off the standard letter from the word processor, and let's forget about them for 56 days. And then day 57 comes round and it's, oh dear, we haven't done anything. We haven't figured out whether they're in priority need or not. We better start doing that. But what the code of guidance here suggests is that where the authority has information it requires to make a decision on whether they're in priority need, it should be possible to notify them on around day 57. So that suggests they should at least have been acquiring that information or actively looking for it rather than just getting it by accident, as it were, if the applicant produces it. And then they've said in cases where significant further investigations are required, it is recommended that housing authorities aim to complete their inquiries and notify the applicant of their decision within a maximum of 15 working days. So that's after the 56 days have passed. So I think what you could do there is you could make a complaint or take them to court and say the code of guidance, is something that has the force of law, as it were. It clearly states they should do this, and as Mike says, there are reasons why that's there, and you could go to a High Court judge and say, please order them to do it. So it
Yeah.
wouldn't be the most urgent case they've done all day, but it would be an important one. So it's not to be overlooked.
Yeah, I think the whole timings and the kind of time limits is something which I would say is another thing that the HRA basically made worse, because there used to be a much more kind of like stringent 33-day time limit on all of it. But effectively, if we go back to the kind of question of, how long should a PHP be issued, for example, like there's LGO decisions where if it's taken more than 2 weeks, the council's getting compensation payments or paying to pay compensation. And in that assessment that forms the PHP, you'd be picking up on most of this stuff anyway. So really, that kind of the idea as Will kind of says, kind of leaving a application, doing nothing for it for 56 days is not legal, although there is not kind of like a hard and fast bit of the code of guidance which says it's illegal, which you just assume it is. Councils have to kind of carry out their inquiries in a timely fashion. If they're just doing nothing for 8 weeks, then that's clearly a breach of that. Just for those who are wondering, who are new to the stream, this is the Homelessness Code of Guidance I've got here. It's called guidance, but it's essentially legally binding. Really, it's telling councils how to interpret the law, and you can just Google it. So, and it's written in layman's terms. It's a good document. It's one of the best documents to kind of, if you want to kind of like learn this stuff in more detail, it's a really good document to go to. And if you've got an issue with the council, you can absolutely quote it. And it's good. It's good for quoting. It's good for kind of it's just think of it as a rule book basically that councils have to follow. So yeah, Will, you mentioned that you'd seen someone kind of take their own case to court and actually did a pretty good job.
Yes.
Is that something you want to maybe talk? We'll come back to another time because
Well, no, I could mention it. Just it's the first time I've ever seen it happen, which is an achievement for this particular client, but is a sad reflection on the state of the accessibility of the judicial review process. That I've been doing this for 30 years now, and it's the first time I've seen it happen. So somebody issued judicial review proceedings against quite a complicated problem with Hackney, and it was about allocation of a property, and they kept getting knocked back. Like they were supposed to put a bundle into court, they didn't get that right. They then had to go away and put hyperlinks and bookmarks, but they didn't give up. They kept doing it, and the judge, I must say, it's a tribute to the judge. The judge went through it really carefully and wrote a really long set of reasons on the order, and said there was going to be a hearing tomorrow. And I was going to represent the claimant at the hearing, but for one reason or another, we thought it was probably better they go along and do it themselves. Um, and But it was an amazing achievement to do that. And he didn't seem to realise what he'd achieved, because I said, "This is incredible what you've done," but he didn't. He just was fairly nonchalant about it.
I
But
mean,
very good, very good.
yeah, it'd be interesting to see how it all ends up.
Yeah, I will. I'll report back as much as I can without disclosing details, but I thought he was probably better off going along in person at this stage, because I it was just too late in the day for me. I only got instructed last week, and it was too late in the day for me to really engage with the case.
Yeah. Cool. Well, yeah. If it's something which is replicable, it'd be good to kind of
Yeah,
I know that I think I mentioned to you that Mohan in the Housing Advice UK Facebook group was basically putting kind of some instructions together of how you actually do it yourself. Didn't look easy, but
it isn't easy.
Yeah,
It's like crossing a bridge, crossing 100 bridges with trolls underneath, and they come up and try and stop you, and they usually succeed.
yeah. Cool. Okay. So next question is this one here. Again, it's a multi-part, so let's just put it back together again. It might be a bit more down below as well, actually. Hold on. Thought we just here we are. Yeah. Yeah. Right. I think I've got all of it. So yeah, let's just have I got all of it? Yeah, I think so. Okay. Right. So what rights does a person in temporary accommodation have after an emergency in the house, such as a fire or arson? Should they be left with no housing support, or should they be allowed to be placed into Airbnbs and then moved every 7 days? And who can they further? Again, I'm not sure if I'm just missing some of this chat here. Let's just have another look.
There's a bit further down. I know you've done that bit, sorry.
Yeah,
And there's a bit people were in.
so
Got that bit. Oh yeah, you got
I
that
think
one.
it's just who can they further the case to? The
right,
personal people who are in a small shared HMO with main duty.
okay, yeah. So I mean, but okay, so basically, you have you're owed the main duty. You have a right. Well, any housing duty, you have a right to suitable accommodation. And so in this case, it sounds like the temporary accommodation that had been provided is no longer going to be suitable because it's been burnt. Um, and so the council therefore has to step in and continue to provide suitable accommodation for that household. And I mean, I guess in a situation where you've got, obviously this wasn't planned, it's kind of an urgent thing. The council probably can say that they're almost treating you as a fresh applicant who's kind of in that initial Section 108 stage. The difference being that although Section 108 accommodation has to be suitable, because it's only supposed to be short term, it can be like less settled. It can be like even more disruptive, and they can use hotels and stuff. So I think you have to give the council a little bit of time to find you something longer term again. Um, and maybe we're talking a few weeks there. I don't know. I mean, I guess if I was in that situation myself, I'd be complaining anyway, just from day one, and just saying, right, my family needs to have a suitable place to be living right now. There's a duty to provide one, and just really push it. Kind of goes back to that whole idea of what a duty actually is. So I've been talking probably quite a lot recently about that case from Croydon a couple of years ago in Malmesbury, Croydon, where Croydon's a bankrupt council, and even then the judge basically said you've got a duty to do something. You have to go find a way of fulfilling that duty. There's no kind of waving your hands and saying that you haven't got the money to do it. So yeah, you could certainly, I think this would be another situation where it's not really going to cost you anything to complain. Basically, not being impolite, but just kind of saying, what's happened, the fact that you've been moved around a lot for a few weeks or whatever, and essentially kind of make them, kind of focus on your case and make them try and find something which is suitable. So I think that's how I would do it. I don't know again if anyone else has got anything to add to that or kind of alter from that.
Not really, no.
No, I think yeah, I think you got yeah. I'd be a little bit patient with them because it sounds like it's just kind of like an unexpected urgent thing that's happened, but don't let it roll on more than a few weeks is probably my answer to that. So if it's been going for like 4 weeks or something, then I'd be putting a complaint in, unless I had some kind of like positive assurance from the council that they're going to fix it soon. But if often what happens is this will happen, and you don't even speak to the same housing officer, no one knows what's going on, so you get left in this limbo again, which is not good. Um, so just a comment here. I think this relates to the noise one we looked at first, and basically just saying that it depends what type of housing someone's in as to what the council might do. If it's social housing, good luck. If it's private rented sector, environmental health might pick it up, but won't provide detail to housing options. I might have just been taking the wrong acronym there. So yeah. Next question. We've got just a comment here, just from a regular. So I want to share some good news and praise the housing officer I met today. The lovely lady was so kind to a very vulnerable friend who is in a stressful situation. A housing assessment was fair. Yeah, they are out there. I mean, I think I have to kind of caveat when I whinge about housing officers, caveat the fact that there are some, there's decent ones out there. So yes, I think it's kind of pot luck, isn't it, as to whether you get a decent one or whether you get a terrible one. But it's good good that person's had a good experience of it. Right, I don't know if this is a question which is in our remit here, but we'll give it a go. With the digital ID coming, when I refuse, can the council or landlord throw persons out? So I don't think the digital ID is coming. I can't see it getting over the line, to be honest. I think essentially, unless a lot of stuff's happened in the digital ID build that I'm not aware of, I don't think it's a question that we're going to know the answer to yet. But I just don't think it's going to come. I don't think there's enough public support for it. In fact, I think there's far too much public resistance to it, and I just think Labour's in a pretty weak position anyway. So I can't see it happening. But I might be misinformed about that. Shannon?
Yeah, I mean, I was just having a look quickly on the small bit of government information there is on this, and the person already might know this, so apologies. But like, so police can't like demand the digital ID. So I don't understand in which situation if the police can't do that, the landlord's going to be able to do that. I think obviously when we're talking about like the council or landlord, there is a part in the homelessness process or a housing process where you'll need to prove who you are. But you wouldn't necessarily have to have that digital ID. It could be some other form of ID or whatever. So yeah, I think refusing to provide any ID could stop a homelessness application or a social housing application or private renting or what have you. But specifically the digital ID, I don't think that would stop it because they would still have enough information to identify you in regards to like homelessness duties and stuff like that. So yeah, and there's also a public consultation that's going to happen potentially next year. And so I just really recommend anyone who has anything to say on this to respond to the consultation. And you don't often have to respond to these sort of consultations as they're laid out. But it's worth doing.
Yeah, I mean, that's a good point. Just any general rule of, if you're ever doing a consultation, bear in mind that the questions they ask are asked in such a way that they're specifically not looking for an actual answer, or they're looking for a very specific answer. And so the best way to respond is just to write a letter and just kind of, set it out how you want to set it out and say what you want to say. I mean, just so again, I have started paying a bit more attention to the renters' rights bill now because it is getting closer to actually coming in. And either in that or somewhere else, there is some kind of responsibility on landlords to ensure that their tenants are not kind of, they're kind of here legally and so on. And I don't know how that kind of, I mean, it's not a question about the digital ID, but it's a question about kind of increased sort of responsibility of kind of, giving account for who your tenants are. But I don't know too much about it. So yeah, I wouldn't worry about that, to be honest. Yeah, I just can't see it anyway. So yeah, right, bear me a sec. So I think that the answer to the question is pretty obvious. If complaints been submitted regarding housing officers and they're allowed to continue shout, are they allowed to? No, they're not allowed to continue. No, they're never allowed to shout and be abusive. Your best bet there is to record them. Interesting to sort kind of see how this Charing Cross police station is kind of unfolding now. And also, do you see I don't know if you saw, I think it was Clarion Housing. I don't know how they did it, but I didn't actually read the article. But they caught a manager basically telling a frontline staff how to forge the fire safety certificate. I think they got sacked for it. But yeah, I mean it's I forgot. I don't know how to say his name. Quadro Twenibo or something. Tweniboa. He kind of was involved somewhere along the line. But yeah. So yeah, I think video recording and audio recording is a really good way to hold public officers to account. And again, I've said it before. Personally, if I was making a homes application, I would covertly record everything and make sure I keep it sort of stored nice and safely for later use, basically. So, not sure about questions about UC. Just kind of go down a bit of a conversation happening here. Right. So here's the next question that I think I can see. How can main duty affect banning on housing register if a family's in higher banning due to overcrowding and homes application? There's a bit more to it. What happens if they get housed under the main duty and temporary accommodation? Will they lose the overcrowding preference? Then their banning gets reduced. So, good question. We can't tell you because every area has its own local policy. And so the only way you can find the answer to that is if you Google your council's name and the term housing allocation scheme, you'll get the policy. And every policy works differently. So there are policies where you actually get a higher banding if you don't make the homeless application, if you just stay put. So let's say you're overcrowded and you're actually homeless because you're overcrowded. There are situations where it's actually better to stay put rather than go down the homeless route. Some councils, it's even like that for domestic abuse. So there's some councils, I think Buckinghamshire is still this way, that if you are subject to abuse or at risk of abuse, you get band A. But if you make a homeless application, you go down to band E and then up to band D eventually. So there's clearly a perverse incentive there to stay put, which I think is outrageous, but I don't live there, so not much I can do about it. So Yeah, I think that's what you need to do. So essentially what you need in that policy, there'll be a banding section which explains what the bands are and which what criteria are met for each band. And you'd basically want to have a look at what band does a homeless applicant owed the main duty. Because bear in mind when you go for a homeless application process, you'll initially get prevention and or relief. Um, and then the main duty, and often the prevention and relief will be like one of the lowest bands, not always, but so you need to kind of see what it says there, and then, and as I say, kind of see what banding you would get if you were living in your home and you were overcrowded. And I'm sure I wouldn't be surprised if there are policies out there that would give the overcrowded family more priority, potentially maybe as a perverse incentive just to kind of avoid making a homeless application altogether. So have a look for that you have to have a look for that basically. But yeah, good question. Might just clarify. So right to rent checks, they've been mandatory for some time now. So yeah, thanks for clearing that up. So yeah, I think there's requirements that landlords have to fulfill to ensure that they know who their tenants are and they've got ID from them. But it's a different question from the digital ID one. So yeah. Okay, so there, I'm not sure if this isn't really a question, but it came in on the channel. And I've got something to say about it, so I'll put it on there. So councils don't have properties. Wiltshire councils state they can't help you if you have a debt with a landlord. Run by a landlords association, it's impossible to get housing. So I don't know Wiltshire. I don't obviously know where Wiltshire is, but I've not had any direct dealings with Wiltshire. Again, it's one of those things where every council does it differently, and some councils don't own any stock of at all, and everything's done by registered social landlords like housing associations, and other councils have all their own stock, and some have a mishmash. Um, and so, but I think the kind of point that it would be useful to say here about debt is that having rent arrears, I'm assuming that's what we're talking about here. Yeah, with the landlords, having rent arrears can be a big problem for you when you have a council that doesn't own its own stock. Because what happens is Bedford's a good example of that. So me and Shannon are from Bedford. It owns none of its own stock. It will have them. It will owe the main housing duty to lots of people because actually rent arrears isn't actually terribly relevant to whether the main duty is owed or not. I appreciate it does come in with intentional homelessness, but not as much as you might think. And so you get households who are owed the main duty, so the council has to house them. But when the council then refers them to a housing association, the housing association says, "Oh, we've got a policy that says we can't have people with rent arrears, or we can't have people with like more than a few £100s worth of rent arrears." It can't be a blanket. So I've talked many times before about my old colleague John complaining to Stonewater about that kind of policy where the applicant was a victim of financial abuse, and so it was kind of ridiculous to then hold that against her. But yeah, generally rent arrears can be a problem. And so again, every council is different, but it does seem that a lot of councils, if you have demonstrated you're making regular repayments over a period of time, you don't need to pay it all off before they will consider you. They want to see that you're managing your affairs well, you're budgeting well, and you're paying rent. So, but yeah, it can be a big problem. I mean, in that situation in Bedford, Bedford would either pay the arrears off, sometimes to the tune of thousands of pounds, or they would just discharge the duty into the private rented sector. So yeah, rent arrears is not a good thing to have hanging over you. I think there is some kind of like time limit on them, like they can't be held against you after 6 or 7 years or something. Can't remember where that comes in, but yeah. But yeah, I thought just kind of mention that.
And just on
Uh,
that point, it's something that like a discretionary housing payment could cover. So it's worth contacting the local authority about applying for a DHP, discretionary housing payment.
yeah, and you might think, well, why is the council going to help you out like that? Well, if you're stuck in temporary accommodation costing the council thousands of pounds every year, it basically incentivizes them to potentially pay off thousands of pounds worth of arrears to be able to get you out of the TA. Karis, do you have any on this one?
Sorry, and with help with rent arrears, there's are some charities that will help fund this if you make an application, like individual grants to individuals. So community foundations, or there's Turn to Us and things like that, that will give you a list of funding you can apply for.
Cool. Yeah, nice one. Next question, not that one. Hold on. Let's grab the right question. So, it's multi-parter. If a person wins a Section 204 appeal against the local council or county court for unsuitable accommodation because of mobility problems and is owed the main duty, will the council act quickly to help the person secure suitable accommodation? Could you please explain how the process would look like? Thanks. So they would have, yeah, I mean, they'd have essentially an immediate and non-deferrable duty to provide suitable accommodation. It wouldn't probably be the settled, final offer, but it would be most probably, well, it should be suitable temporary accommodation that kind of takes into account the mobility issue. So this company, I mean, this is kind of something that Will often says, the can the council get away with not doing it? Well, yes, they can. Well, they can try to anyway. So it might be horrendous that you win the court case, and then the council still delays in actually kind of providing the actual or discharging that duty lawfully. But you would hope that if the council had just lost, that they would be quick to act. They would kind of take all reasonable effort to get a quick outcome. Will or Karis, I don't know if you've had experience of like how that sort of thing works in practice, or if you see it. I don't know if once you've won the 204 appeal, whether you have further engagement with it.
I could say a bit about that. It comes back to the what you were saying about the Croydon, the Imam type situation, and El Kundi, where the council are under a mandatory duty but don't do anything to discharge that duty. And let me just check the question. So, if you win a homelessness appeal over unsuitable accommodation, then the council, well, I'm assuming that the decision means that they're under a duty to provide suitable accommodation. The question is, how long can they be allowed to get away with? Because obviously, without being stupid, but this is conceptually, if you win the appeal at 4 p.m. on a Tuesday afternoon, you're not going to be able to go for a judicial review the next day to say they haven't given me any accommodation yet, because the judge would say, well, hang on, give them a bit of time. It's only yesterday. But equally, there comes a point at the other end of the scale or the spectrum where the judge would say that's outrageous. They're under mandatory duty. They should have done it. And the question is, how long would that be? And this was decided recently. I don't know if I mentioned it. There's another of these cases that follows on from El Kundi and Imam, because there's two questions. One is, when is the council acting unlawfully? And a second one is, when will the court actually order them to do it within a specific space of time? And usually in Imam and El Kundi, I think it had been years. They'd been waiting months and months and months, if not years. And then there was a case earlier this month called Hamad on the application. It's a judicial review. Hamad basically versus the Royal Borough of Kensington and Chelsea. And that was significant because Mr. Hamad had only been waiting for a period of weeks. And the court did make an order and said they had to give them suitable accommodation within 12 weeks, which means the courts are reducing that time, and they're being quite tough. Because in the old days, the courts would say, oh, well, we can't really tell councils how to do things. But they recognised through those two cases, Imam and El Kundi, that what's the point of having rules if the court can't enforce them? So they are getting tougher. So the answer to the question would be yes, they should. But so how quickly? I mean, you should be looking. I think if they haven't given, I mean, it depends how acute the need for accommodation is. Obviously, if you're in accommodation and you can't access it, in Hamad they needed to be in accommodation near to a hospital because the son had special needs, and but in other cases it depends on the severity. But you could start saying, if it's been, I would say sort of 3 months, 12 weeks is starting to be a point where you could say, right, we're going to go for a court order. So I hope that helps, but it depends on how badly you need the accommodation.
Yeah, Matt, I think if it was something like the other end of the scale, where you've got someone, let's say a wheelchair user, and the property they'd been given had got 10 flights of steps or something,
Yeah.
then that situation, at the very least, the council's presumably going to have to source hotel accommodation that's accessible in the meantime until they actually get the kind of final offer again. There's just an addition to the question, back up to this one here, question 4. So regarding sending complaints about B&B moves, who should it be addressed to if multiple housing officers and admin are involved? So you've got a couple of options. One is to just follow the council's complaints process. So if you just Google the council's name and then complaints process, you'll find it. They're pretty accessible on the websites. And there'll be like a complaints at bedford.gov.uk or whatever. So you can send it to that address. Personally, I'll find out who the chief exec is and I'll send it to them. And there are some other things that you can do as well to potentially kind of move things along. One is kind of going to speak to your local councillor. Now I know I know some people don't kind of respect this kind of approach, but it's a good approach. Basically, your councillor's there to represent you. They can't make decisions for the council or anything like that, but they do have a good effect in terms of just focusing the council officer's mind on actually doing their job properly. So and it also just informs councillors about the kinds of situations that people are struggling with. As I say, if you've got a whole load of people, which we do have in terms of people who are homeless, people really struggling to get treated lawfully, but councillors don't know about it, then they're not going to steer the council in a better direction. So actually, when you go and speak to a councillor about a problem that you've got, you'll be speaking for yourself, but you'll also be helping other people as well. You'll be educating the councillors and kind of improving the chance of them actually making some good decisions. So if it was me, I'd send it to chief exec. If you're a polite normal person, you probably send it to just the complaints team. And I think so it's not, just bear in mind, it's not complaints where you're kind of singling out a particular housing officer because they you don't like them, or because they were idiots or whatever, is not a good approach. You just want to basically don't say, oh, this officer did this. Just said the council failed to do this, the council has a duty to do this, they haven't done it, rather than just trying to single out people, because it just makes it just makes it unpleasant basically. Cool. How many of the time we're doing? All right, so you've done that one. So I put this kind of on the list. It's not a question that's coming, but I just thought it might be interesting to talk about a bit, which was just joint tenancies, as in what are they and pros and cons of them. And I don't know the answer to this really. I mean, I know a bit about them, but I'd just be interested to kind of just explore this just briefly here. So, and because what I do know is there's quite a few situations where the fact there's a joint tenancy involved can kind of complicate things quite a lot. So I'll kind of start with the bits I think I know about this stuff. Hold on a minute, where's the? Just write it down. Joint tenancies. I've just put that one in twice. Joint tenancies. So basically, very quickly. Obviously, joint tenancies is a tenancy where there's a two more. Well, I guess potentially more than two people who are on the tenancy, and there's this term called jointly and severally liable, and this is kind of where some problems kick in, because in effect, if you are a joint tenant, then you become responsible for the behavior of the other tenant. So if the other tenant's a nightmare, then you can be held accountable for what they did. So for example, if the other tenant accrues loads of rent arrears or something, then you are liable for those rent arrears, and potentially the landlord or the council might think it's easier to come after you rather than the other tenant who might have just vanished. So that's something to bear in mind. And also another thing to bear in mind is that one of the tenants can end the tenancy without the other tenant's knowledge or consent. And so, again, this often comes up in issues where you've got domestic abuse, because often, there's just, it adds another layer of complication to the kind of the solution to that situation, in that if you've got one of the tenants is being abused, they want to flee, then there's just some consideration that needs to be had around what they do with that tenancy, because again, if the victim leaves and moves somewhere else and the perpetrator remains there and trashes the property, then in theory the victim could be liable for what the perpetrator's done. So I mean, I kind of put in there like pros and cons. I actually can't think of any pros to a joint tenancy. I guess there might be some, but I can't really see a situation where the tenants are actually better off with a joint tenancy rather than just having one tenant and the other person just kind of lives there as a, whatever the word is, a permitted occupier or whatever. I don't know. I'm well out my depth here in terms of the legal jargon here, but yeah, I don't know if you guys have got anything to say about this issue, in terms of if they're good things or bad things, or what you need to watch out for.
I could go on for a very long time about joint tenancies because they're sort of something that comes up as a fairly common thing in housing law. Most of the stuff from a tenant's point of view is probably negative in that it's got things like joint liability for rent arrears. One tenant can terminate the tenancy on behalf of both of them. So if your abusive partner moves out, they can surrender the tenancy on behalf of both of you, and as a sort of continued act of abuse. I'm trying to think of some other ones, but I just did a ChatGPT thing, and I've said to it, "You are a specialist UK housing lawyer. Prepare a table with 10 rows showing the pros and cons of joint tenancies," and it hasn't come up with many pros.
What are there any actual pros?
Not really. I mean, there are things like, yeah, they've come up with 10 things, but it's like simpler for landlord. One contract, tenants can cover each other's shortfalls, combines incomes to pass affordability checks and share costs. But they're not.
That's what I was going to say about the affordability. Like, don't you have, it's easier often for, I think, for estate agents, isn't it, to say, oh, well, you're both on the tenancy, so we can take in both of your incomes. I think particularly for like self-employed or what have you.
Yeah, I mean,
Yeah.
this doesn't really tell much. I mean, I suppose that the advantage of a joint tenancy, the most obvious one I can think of, is that the person who is the sort of second tenant has greater rights as a result of being the tenant and a joint tenant than they would if they were just somebody who was an authorized occupier, because they would have, if the tenant died,
Yeah,
then the joint tenant would succeed to the tenancy, whereas they might not necessarily succeed under the laws of succession.
yeah. I mean, that is a pro, the right to survivorship,
Mm.
isn't it? Yeah. It automatically goes to the other tenant, the surviving tenant that hasn't died.
Yeah.
So when someone dies, so that is so it does ease the burden on the tenant that survived of having to deal with all of that. So that kind of is a pro.
I mean, I think, I might be something we return to another time just to kind of go in into a bit more depth on it. Because so I've seen it come up a few times, and it can be real kind of difficult to navigate. So I'm just putting the link to the Hammered case in the chat as well, guys. So gives you a bit with it's it's a Nearly Legal kind of blog on it. So again, if you're interested in this stuff and you haven't subscribed to Nearly Legal, do so. Very, very helpful resource. Now, so what am I doing next? The next question is PHP and inaccurate PHPs, and I'm just trying to multitask here because let's just first of all stick it in the no, not that one. Hold on. Let's first of all add it to the questions, and then I'm just going to go to the database. What's it doing? I think that's it. Yeah, cool. So yeah, if PHP is done with incorrect information by housing officer and got option to review it, is it good to review? Well, yeah, absolutely yes. Particularly if it's important, because it's a legal legal document where if something's wrong in there, then it can definitely come back to haunt you. The reason I'm just trying to multitask here is that I did one of the cases I was looking from the LGO today. So this is just a PDF of the LGO decision database, which I need to reformat and stuff. But I'm just trying to think. Inaccurate PHP, I think, is a here we go. So London Borough Wandsworth. One of the elements of this case was the fact that the PHP was inaccurate. So if I just quickly go and find this case on the LGO website. Bear with me, guys. I'm just trying to find everything. So if I share that now, here's the actual case. So I'll put this into the chat as well. yeah, basically this is just a case where I haven't even read the details of it yet properly, but yeah, essentially where one of the elements was is that the personalised housing plan wasn't correct. So again, this is why I love the LGO, man. The LGO lay out what the law is. So councils must complete an assessment if they're satisfied an applicant's homeless. So it just basically says what they have to do. And I think it also says about, you know, making sure they're kind of kept up to date. And whatever happened in this case, somewhere along the line, the PHP was wrong, and I guess it made a difference somewhere further down the line. And so it mattered. So in this case, they got a £10,000 compensation, but it wasn't just for the PHP. That'd be pretty good money there.
Yeah, I would. Yeah.
There'd be a number. It most likely be suitability of accommodation. It was. Oh yeah, this is actually this appears to be the whole being told to wait for the bailiffs as well. So yeah, I mean, I'll put the link into the live stream chat. You can have a little look for more detail. But yeah, the short answer to the question is, yeah, definitely correct them because it matters. And yeah, it should. I mean, they should make it straightforward to correct them, really. But we never know. Oh yeah, nice. So just someone saying that they're from the yeah, they know the person who basically assisted in the Wandsworth case. Nice. Bear with me a sec. Where do we get up to? Oh, it's saying error. Okay. So I've not been able to put that link into the chat, it seems, for some reason. Oh, what's it doing? YouTube's been weird, guys. If I'm crashing, then I'm sorry. Right. Next question is this one. Okay, 12. A friend is homeless intentionally and has been sleeping on streets and has been assaulted by an abusive ex-partner and went to the police. The council still won't help her. Is this normal? Okay, so good question. Right. There's a couple of things I guess I'd want to know if I was dealing with the situation. The first thing I want to know is the person actually intentionally homeless, or did the council just say they were when actually they weren't? Because it's quite difficult to actually be genuinely intentionally homeless. But let's assume first that yes, this person genuinely is intentionally homeless, and since they've been found intentionally homeless, the council had a short-term duty to provide temporary accommodation, but that's now ended. They're now sleeping on the streets, and whilst they're sleeping on the streets, they've now been assaulted. And the council still won't help us. So is it normal? It's normal, but the question is it legal? What definitely is legal would be for this person to approach any other council in the country. So that's easier said than done because as we know, there's plenty of examples. In fact, I've literally just been doing loads of LGO reading through them. There was literally one, I think it was Enfield, where there's someone approached, they're having fled abuse, and they were just literally sent back to their home area, which is obviously unlawful. So legally speaking, you can go to another council and they'll certainly have a very short-term duty to house someone in this situation. It's highly likely they're going to be vulnerable. And interestingly, let's say council A found you intentionally homeless, you're then rough sleeping, you're then assaulted on the streets, you go to council B, you ask for help with housing, you give them the reason to believe they might be homeless, which should be easy because it's a low threshold. So council B has to accept the homeless application because local connection is not relevant. You then get interim accommodation, or you should do, because there would be reasons to believe that you might be homeless, might be eligible, might be in priority needs. So you've got a roof over your heads, and only then can they start sniffing around local connection. Now, one thing I would say as well is it's not difficult to have more than one local connection. It's not unusual to have 5, because of the way it's set up. You've got different residency requirements and family connections and so on. So if you have a local connection somewhere else, go to that council. You're going to get more out of them. So if you've got a connection to council B because you've got a sibling who lives there, then you've got a local connection. You can go to council B. So that would be plan A. That would be kind of short term. But as we know, councils break the law every day, and they don't care if they break the law to domestic abuse survivors. but it's just they're not bothered. So what you really could do is a good advocate to actually help you with that process. But another thing that might kick in is that I would be interested to know what was the reason for you being found intentionally homeless, or for this person being found intentionally homeless, and would the abuse that's going on here have any kind of bearing on that? Because it's not unusual for survivors to, kind of lose their home because of their actions of their partner, but they're not quite, that sort of stage of recognizing it as abuse. And then the abuse escalates, and then it does become clear that, actually it definitely is abuse, and therefore that would have a bearing on that original decision. So there would be situations where the assault would actually potentially be new information, which would allow a second fresh application to the same council. But I appreciate all of that I've just said is rather complicated and convoluted. What I'd say is you want a decent advocate. Unfortunately, they're not easy to come by. Is probably my answer. And you guys want to add to that? Or yeah,
I think you've covered most of it. I would think that the problem here is if the person is genuinely intentionally homeless, and we shouldn't assume that they may have just been told they are, then none of this would necessarily break the chain of intentional homelessness. Because once you've got to your second homeless application off the ground, whether it's to the original authority or a new one, they could still say, oh, well, you're intentionally homeless because the last settled accommodation you had was lost as a result of whatever it was that made you intentionally homeless. But remember, there's the duty under Section 190. I feel like a scratched record. I'm always saying this, that if you're intentionally homeless and you're in priority need, then the council have a duty to assist you in finding accommodation and to provide you with accommodation for a reasonable period while you do so. And if you're intentionally homeless, they would presumably have found that you were in priority need before they found you intentionally homeless, because that's normally the sequence in which the decision making goes. And even if they didn't, the fact that you've now been abused on the street might be an indication of how you found it more difficult to cope. So you could probably get something through remaining, even if you can't challenge intentional homelessness, you've still got rights because of being in priority need.
it's an interesting point you'd raised there, Will, about I need to read the law again, actually, like whether someone who's found intentionally homeless must have therefore been found in priority need. The reason because I agree with you, I certainly have seen decisions where they'll say you're not in priority need and you are intentionally homeless, and it's
Yeah.
almost like they're doing that because it just makes it harder to come back again later on down the line. So it's an interesting question as
Now,
an aside.
I think in the old days, there used to be just a procedure they did it. I think it was partly because it was easier to tell people they weren't in priority need and then not bother about intentional homelessness, because the categories are more sort of easily defined, aren't they? And you don't have to do big inquiries into all those factors for intentional homelessness.
Yeah.
Um, could I
Okay.
say something very quickly about personal housing plans? Because there's a question in there.
Can I jump in really quickly on this one?
Sorry.
go
Oh,
for it.
yes.
Just
Sorry,
'cause
Shannon.
no, it's all good. I don't know if it's been mentioned because I'm obviously paying really hard attention. So apologies if it has been mentioned, but I don't know if it would potentially be worth a safeguarding alert. Again, it just adds sort of strength to the case, and potentially you are in a situation where you're going to struggle to protect yourself from that harm. And then there was another point I was going to make, and it is completely. Oh, that was the point. So obviously, Will and Mike, you're spot on around the intentional homelessness and stuff. But I also wonder, just because we've seen it so many times, whether actually a friend's approached the council and just like the front desk has verbally told them they're intentionally homeless, and no decision has actually been
Yeah,
made.
yeah.
So, just if that's the case as well, it's worth going back and like formally making a homeless application, requesting paperwork, requesting copies of things, doing it via email. Mike's got a brilliant video on the channel around sort of the top tips to make a homeless application, just because I think in this situation, I feel like this is potentially a situation where local authorities would potentially do that verbal gatekeeping. So yeah, that was it. Sorry, carry on,
That's
Will.
It was just to add as well, just before Will comes in, because you mentioned safeguarding. Yeah, absolutely right. Also approach domestic abuse services at this point, because So independent. Well, domestic abuse workers in general tend to they have a bit more fight in them, in my experience. They're more willing to kind of actually take a counsellor and kind of help someone out. So as well as that, like approaching a domestic abuse service of some kind, whether it be by requesting an IDVA, or whether it be just going to kind of a women's centre or something, or yeah, I mean, just some kind of service that would be a gateway into some other assistance. Because one thing, if you went into, like, yeah, if they're having in Bedford and you wanted into the women's centre, they do a dash referral, you get an IDVA, and the IDVA can be very, very helpful in a number of ways. So that's something to bear in mind as well. Is just kind of that there's other support out there which won't immediately put a roof over your head, but it could lead to it. And actually having a professional who knows what they're doing in this sort of situation would be very helpful. Karis?
Sorry, I'm debating on this one as well. The police should have triggered that IDVA and domestic abuse help. And that's something you could also talk to your doctor about, and they could write up a letter for you if you had any evidence of things like that and medical reports.
Yeah, I mean, call me cynical now, but I mean, I've just been following that Charing Cross police station report a little bit. So I think it's entirely possible that the police wouldn't have done what they should have done and would have been pretty unpleasant about it all. But yeah, there are decent ones out there, as there are decent housing officers. So yeah, so there's one more question in before the deadline there, so we'll do that before we finish. But Will, I don't even know, I've forgotten what you were actually saying now, because
I
we've
was
just
saying,
gone off on a
just a very
tangent.
quick word about personal housing plans, because there's a question there about if somebody gave the wrong, if PHP done with incorrect information by HO and got option to review, is it good to review? I'm I'm just going to say that there's a lot of confusion over personal housing plans and the housing needs assessments, which are supposed to go into them. And this is a Homelessness Reduction Act 2017 creation. There's a case, if anyone's interested, another case which I think is starting to put to bed arguments about personal housing plans, and it's nearly legal. It's called Fatola Zadeh versus London Borough of Barnet. And I'll put a link in the chat. But what that held was that that there have been cases where lawyers have been trying to argue that the duty to carry out a housing needs assessment means a bit like a Care Act assessment or a Children Act assessment. The end result is a discrete report, a document saying this is the assessment report. And if they hadn't done that, then any decision they make, whether it's under the personal housing plan or on suitability later, is invalid because they haven't discharged the duty to do the assessment. And that's conceptually wrong because a local authority which made a perfectly suitable offer couldn't really be challenged for acting unlawfully if they hadn't done the assessment. This case here goes into it in detail, and I won't go into the only point I'll make is one of the crazy things about personal housing plans is you can't challenge the actual plan. It's the housing needs assessment and the comments about you in the plan by way of a housing review under section 202. You can only go for a review of the steps which the council proposed to take. If you want to challenge the information like this question is asking about and the way they've done the assessment, you have to go for a judicial review, which I don't think I mean, I think people regret that. I mean, there should be an opportunity to go for a 202 on that. I'm sorry if that's a bit garbled, but
No, it's cool. I remember in Jan Luber's textbook, he basically kind of says it's very odd that there's not that ability to challenge it kind of more in a more straightforward way.
yeah,
But yeah,
I don't think they really thought through what they were asking for.
I don't think they thought through any of it, Will, like the HRA.
No.
Yeah, anyway. So last question is this one here. Hold on a minute. So yeah, housing officer forgot to give PHP after 7 weeks. The applicant reminded housing officer. Now housing officer closed the prevention case after next day and gave the family relief duty, and she gave option to review to finish the prevention. So okay, so the council's broken the law there, but I don't think it makes too much difference really, or it's now an academic point, let's put it that way. But what they should have now done, now that you've gone from prevention to relief, is they should update the personalised housing plan now. Now, again, there's no time limit set out in the law, but the Tower Hamlets got criticised by the LGO and had to pay compensation when they took 10 days or 10 working days, I think it was. So clearly the whole point of a PHP is to be done at the beginning of the relief and prevention duties in order to inform what the hell the council is actually going to do to help you. So yeah, it's clearly a failure of the council to not do a PHP, and if you complained about it, you probably get 100 quid from the LGO. But what's probably more important at this point is that the council now do an updated PHP now that's got the reasonable steps that you and they will take to try and get you housed. So yeah, there's also a question at the end there about diabetes and priority need. The answer is potentially. If you search for the term priority need on the YouTube channel, there's a bunch of videos which kind of explain how it all works. There's no kind of like paint by numbers sort of, you know, this diagnosis is, this diagnosis is not. It's always a question of how you're affected by, you know, how it'd be affected by being homeless. So we've run over there, guys. So I lost track of time slightly in there. So apologies, you guys, for holding you back. But we'll be back next week. As I say, if you're interested in coming along to the free webinar next Tuesday afternoon, check out Eventbrite. I think it's designed to kind of introduce the basics to people who probably haven't got a background in housing law and housing option stuff. So yeah, check that out. Other than that, we'll be back in a week on next Thursday. So yeah, thanks guys, and yeah, hopefully this evening's been helpful.
Yeah.
Keep the questions coming.